Okay, so thank you everybody for being patient and welcome to our estate planning workshop today. My name is Stephanie Maeda and I'm the program manager at the Gardena Valley Japanese Cultural Institute. So thank you all for being here today. We're really excited to have this presentation. But just a couple things before we get started. So I'm going to ask that everybody remain on mute while Stacy is presenting. If you do have any questions, feel free to leave them in the chat box. Otherwise, we will have a Q&A session at the end of the presentation, and then we'll allow you to unmute and ask your questions verbally if you would like. And also, if we have any extra questions at the end, they can also be emailed. Otherwise, I would like to introduce our presenter for today, Stacy Toji. She's an estate planning attorney at Toji Law. So thank you, Stacy, for being here today, and it's all yours.
Perfect. Thank you so much. Good afternoon, everyone, and welcome to the Estate Planning 101 webinar. My name is Stacy Toji, and I'm the principal attorney here at Toji Law. So before we begin, I just want to first off start off by thanking Stephanie for having me here, as well as the entire JCI. It's really an honor to be a part of this adulting series, and personally, I think the topic of estate planning fits right into that category. So putting together your estate plan is probably one of those things that has been on your to-do list for a while, but isn't really a top priority just because other things in life come first. And it really isn't one of the top priorities when you're young and healthy. So, one of the goals of today's presentation is really to help explain why it's best to start creating these legal documents sooner rather than later. So let's get right into it. Since this is kind of an introductory 101 type seminar, the first point I'd like to tackle is what an estate plan actually is. So when I use the term estate plan, it's really an umbrella term that covers the major documents that are needed to ensure that, all of your affairs are in order in the event that you pass away or become incapacitated. And those legal documents are: 1, the revocable living trust; 2, the pour-over will; 3, a durable power of attorney for finances; 4, an advanced healthcare directive with a HIPAA release; and 5, a quitclaim deed or other similar document to transfer your real estate into the name of the trust. And we will go through each and every one of these in more detail, and we'll start first with the revocable living trust. So what a trust is, it's really a legal entity that holds and protects your assets, and it's the most important document in the entire estate plan. And there are a lot of different benefits to creating this type of document, but really the number one reason why most people have one done is to avoid probate. So let's just take a step back and talk about what probate actually is. So for those of you who might be familiar, a probate is the legal process that occurs if you pass away without a living trust in place. And, one of the things my clients always say to me is, I don't have much, I just have a home, I have some bank accounts. And for that reason, a lot of people think they don't need a trust because their estate is so simple. They probably have 1 or 2 kids and they say, when I'm gone, my kids are going to get everything anyway. But that won't happen automatically. So that's not necessarily the case. The other misconception is that people think if they have a last will and testament, they're also saved from probate. This is also untrue. So for those of you who might have heard of the probate process, you know that it's a real big headache. And that's because, 1, it is a lengthy process. So here in the state of California, probates used to take about 9 to 12 months. However, the pandemic hit and the courts were closed for a significant period of time. So now they're trying to play catch up with their caseload. So now the estimated time frame for an LA County probate is about 18 months. So from start to finish, a year and a half. Orange County is even slower. The probates that I have there right now are taking about 18 to 20 months. And that's just for a simple case. Like I said, maybe 1 home, a couple of kids, no fighting. Complicated cases take years and years to close. So if your estate has to be probated, your family members, they won't be able to access your home, your money, and all of your other assets until the whole process is settled. Even though in the meantime, before the probate is closed, things like your mortgage and property taxes are due. So your family members are kind of in this limbo state where they're responsible for paying all of these various bills, but they don't have access to your funds or your assets to pay for them. Also, with probate, you really have no control over what happens to your estate. So without a living trust in place that clearly states what your wishes are, it's a judge who instead determines, who manages and inherits your assets. That means that all of your hard-earned money could potentially wind up with, an estranged brother or a spendthrift nephew. And finally, the probate process is expensive. So probate fees are what they call statutory. And what that means is that it's actually the court, the judge, not your lawyer, who determines the cost that you'll have to pay in order to close this probate. So let's take a look at kind of a famous probate case to get an idea of what this process looks like. So probably everyone has heard of Howard Hughes. He was an eccentric billionaire. And when he passed away at the age of 70, he surprisingly didn't have a will and trust in place. So his estate had to go to probate. So as you can probably imagine, when he died, the vultures just descended. So there were over 30 wills claimed to be signed by Mr. Hughes that were submitted to the courts, none of which were deemed legitimate, by the way. And then all of these secret wives, illegitimate children, and distant relatives emerged out of the woodworks. So because the courts had to sift through each and every one of these claims, the estate took 34 years to settle, only closing in 2010. And even though, everyone knew that Mr. Hughes hated his family, wanted his fortune to be sunk into his foundation, the judge had to follow the estate planning rules of intestacy, since there wasn't, again, a trust that said what Mr. Hughes actually wanted. So what intestacy means is that there's a predetermined order of people who inherit your property if you pass away without a trust. So as a result, his entire fortune ended up with 22 cousins, some of whom were distant relatives and he had never even met before. And because this probate spanned 4 states with all of his holdings and took years and years worth of attorney's time to sort through, the probate fees ended up being about $10 million. Now, this, of course, is really an exaggerated scale of what the consequences of probate look like. So for those of us who are not in Howard Hughes's tax bracket, I have a more typical everyday example of how probate plays out. So my husband and I have been house hunting for almost 4 years now, and I was just telling Stephanie that Derek Carano, who had done another adulting series, he just helped us secure our very first home. Thankfully, we closed on Wednesday. So I know from personal experience how crazy the housing market is right now. And I took a look at Zillow last night, and it looked like the average home in the South Bay and Torrance Gardena area is about $850,000. So of course, some homes right now are much, much higher than that, and some are lower. But just for the purposes of this example, we'll use $850,000 as the price of your home. So if you pass away without a living trust in place, these are the probate fees you would ordinarily pay. So there are things like filing fees, publication fees, inventory and appraisal, attorney fees, executor fees, etc. So for an average probate, where an individual has one home, you're looking at about a $40,000 probate fee. This is what your family has to come up with before they're able to get any of your assets. Of course, every case is different, and this is just an approximate number, but it is extremely typical to pay tens of thousands of dollars in probate fees, which is why creating a living trust is so important. So another advantage of the trust is that it allows you to retain control over your assets, both during your lifetime and after you pass. So with a trust, you're able to name the beneficiaries of your estate, essentially who will inherit your assets after you're gone. And what's great about a trust is that it's completely customizable, meaning you can say, when I'm gone, I want everything to be split 50-50 between my 2 kids. Or you can specify, when I'm gone, I want my home particularly to go to my son, but to be fair, I want my bank accounts to go to my daughter, and I want my vintage car to go to my grandson. You can even donate through the trust to a church, charity, or other nonprofit organization. Another way you're able to retain control is by appointing a trustee. Now, some people are more familiar with the term executor, but when you have a trust, the term that you properly use is actually trustee. They're interchangeable, though, for the purposes of this workshop, if you want to use executor. So the trustee is going to be the person who handles the affairs of the estate after you pass. And the main responsibilities are, one, to make sure your debts are paid. So if you do pass away with, American Express bills, or if you have hospital bills, those get paid first from your estate. So one thing to note is that your trustee is never personally liable for paying your debts. So if, at the end of the day, there's no money to pay off the bills, then the trustee isn't liable for that. They're not responsible for the remaining balance. The debt just goes away at that point. But then there's also no money to give away to the beneficiaries. The other responsibility of the trustee is just to gather up all of your remaining assets and distribute them to the beneficiaries. This job is fairly simple. Really, all of the trustee has to do is follow the instructions that you've clearly laid out in your trust. And in terms of who the trustee can be, it can really be anyone of your choosing. I would say a vast majority of people choose their family members. Usually parents choose their children or, siblings, but people also choose their friends or other family members. People also can be beneficiaries as well as executors. That's a question I get a lot. Can my son inherit my assets and still be the executor? The answer is yes there. And if you're having trouble, coming up with someone to serve, you can always appoint a neutral third party like a bank, a CPA, or someone called a professional fiduciary to serve as your trustee for you if you don't want to, bother or burden any other friends or family members for this role. Now, because you've selected the trustee beforehand, you're in full control over, who gets to manage the estate when you're gone. And lastly, because the trust is revocable, you have the freedom to modify any and all provisions at any time. Nothing's ever set in stone. So if you decide, 10 years from now that you want to remove a beneficiary or change a trustee, you have the absolute right to do so. Yet another advantage to having a trust is the ability to protect the interests of your beneficiaries. So let's say that you nominate a beneficiary like a child or a grandchild who is a minor. By setting up a living trust, you're ensuring that their inheritance is safeguarded until they turn 18, which is the legal age of majority where someone can inherit. So up until that point, the minor's inheritance gets kept in a trust fund that is governed by the trustee. And then, so usually what my clients say is, 18 sounds a little young for my child to inherit a home and potentially hundreds of thousands of dollars. So with a trust, you're able to choose when and in what percentage the beneficiary ends up inheriting the assets. So this is called a tiered distribution. So for example, you can give your beneficiary 50% at 25 and 50% at 30, or you can say, I prefer if my daughter got 100% when she turns 27. So what's beneficial about doing this type of tiered distribution is that your beneficiary can still access their inheritance for very limited purposes, such as education and health. Meaning your daughter can dip into her inheritance if she needs it for college tuition or medical bills, but she can't just blow it all on a trip to Vegas on her 21st birthday. This type of tiered distribution is also really useful if you have a beneficiary who's irresponsible with their money. So if you want to make sure that this person doesn't blow through their inheritance all at once and they kind of have a little nest egg for the future, you can add specific language into your trust to space out when they'll receive their inheritance, or you can nominate another person to manage that person's spendthrift inheritance throughout their lifetime. A trust also helps protect beneficiaries who receive public benefits. So normally, if you do name a beneficiary who receives things like SSI, Medi-Cal, or other type of government benefits, they lose their benefits because they receive an inheritance. But there is a special type of provision that you can insert into the trust. It's called a special needs trust, and that allows them to both maintain their benefits and receive an inheritance. So it's the best of both worlds for that beneficiary, but it can only be accomplished through a very specific special needs trust. Okay, moving on. So one of the biggest concerns that people have when it comes to their living trust is regarding taxes. So one of the benefits of creating the trust is the ability to eliminate, or at the very least reduce, the amount of taxes that are due when you pass. Estate taxes, probably for the purposes of this webinar, are not much of an issue. And that's because you can have right now up to $11.7 million in assets when you die without paying any taxes. So, if you're not a multimillionaire, you're not really concerned about the estate taxes. Really, your focus is the property taxes and capital gains taxes. So I'm not sure if you guys have heard of Prop 19, but this is a brand new proposition that was passed in this most recent November 2020 election. So let's look at what that means. So Prop 19 was voted in November, but it officially took place or took effect on February 16th, 2021. So for the older generations that are present here today, if your parents passed away before 2/16/21, then when it comes to the primary residence, the family home, the kids could keep the property or they could rent it out and they would face no reassessment. Meaning the kids could inherit their parents' property tax basis and the property taxes wouldn't increase. This is huge if you're under Prop 13 and the property taxes are low. I've had my clients pay $500, $1,000, $1,500 in property taxes, and then when they passed away, they passed on that property tax basis to their kids. So it's a huge, huge benefit. Also, if your parents passed away before 2/16/21 and the kids decided to sell the property, then there would be little to no capital gains taxes that would have to be paid. And really the amount of capital gains taxes, if any, that you pay just depends on how long you wait to sell the property and what the value is at the time of sale. So it's hard to determine if you have to pay anything. It's more of a case-by-case basis and the value of the property. Now, for rental properties, the kids were able to keep the rental property as a second home or rent it out, and again, face no reassessment as long as the assessed value of all of the rental properties was lower than 2 million. I know that sounds like a mouthful, but basically if you looked at all of the rental property values, if the assessed value was under 2 million for all of them combined, no reassessment. And the keynote there is that I said assessed value. That's what the county believes the property is worth, not the fair market value, which is what it goes for sale on. So a lot of the times, a home in Torrance is for sale for 1.1 million, but it's assessed at 400,000. So there's a big difference. And if you want to know what your assessed value is, you would look at your property tax bill. Okay. And again, with rental properties, if the kids decided to sell that prior to February of this year, they would face little to no capital gains taxes. Now, unfortunately, the property tax exclusion only applies when children inherit property from parents. So if an individual does not have any kids, then his or her beneficiaries, whether it's siblings, nieces and nephews, or friends, the beneficiaries would have to pay increased property taxes and also for fair market value for the home and rental properties. So this is the proposition before 2/16/21. So now let's look at what it currently is. So if you as a parent or your own parent, you as a child, if they pass away after 2/16/21, which is basically right now from here on out, then in regards to the home, if any one of the children remain in the parent's home, then there will be little to no reassessment. And whether or not the property actually gets reassessed, it just depends on the value of the home at the time of your parents' passing. So again, you would have to look at that valuation, and then there's a calculation that the county provides to see whether or not the property will get reassessed. It almost for sure will not be a full reassessment. It'd probably be minimal or partial. Now for the home, if the kids keep the home but choose to rent it out because they have homes of their own, then the property will be reassessed and the kids will have to pay property taxes based off of fair market value. So this is fair market value, it's not assessed value. So you would see, what the home would sell for, and the property taxes would probably be about 1 to 2% of that amount. Now, if the kids sell the home, this part has not changed. They would still pay little to no capital gains taxes. For rental properties, this is a big change. All rental properties will be reassessed, regardless of whether the kids, keep them as a primary residence or rent it out. It still will be reassessed. So there's no more $2 million exclusion for assessed value. All rental properties or secondary homes, vacant lands, anything that's not a primary residence, that gets reassessed to fair market value. And then again, if they sell it, still no change here. They would pay little to no capital gains taxes just based off of the increase in value. The same applies to individuals without kids. Prop 19 still only allows a home exclusion for children. So if you don't have any children and you pass it on to friends or other family members, it will get reassessed to fair market value. So Prop 19 was a major, major change to the law, and it negatively impacts, a lot of us here. We can always hope for a repeal of Prop 19, but just until that time comes, the only thing you can really do to mitigate the capital gains taxes is to create a revocable living trust. So, hopefully by now I've kind of made my case for why creating a trust is so important. But as I mentioned before, it's not just the trust that you need, it's actually the entire estate plan. So one of the complementary documents to the trust is the pour-over will. So usually when people come in to see me for an initial consultation, they say, okay, well, what is it that I need? Is it the will or is it the trust? And what's the difference between the two? So they're really similar in many ways. In each one, you appoint someone to handle the affairs of your estate, you name beneficiaries, but there's one major factor that determines whether you need a will versus a trust, and that's whether or not you own a home. So the moment you purchase a home, you need a trust, plain and simple. Otherwise, you'll be subjected to probate after you passed. So then the next question people ask me is, okay, I understand that I need a trust. Do I still need a will, even if I have a trust? And the answer is actually confusingly, yes. So the will serves as a backup device to the trust. So let's look at an example. Let's say, you have an IRA out there from your first job 40 years ago. And at that time you were young, so you named your parents as the beneficiary. So at the time you pass, your parents are gone and there's actually no more beneficiaries named on the accounts. It won't just automatically go to your kids simply because they're your children. If you want it to go to the kids, we would use this pour-over will, which says that it was your intention that all of your assets were supposed to go to your family members, regardless of whether or not they were actually named as beneficiaries on an asset. So it's kind of this cool, catch-all backup device that we use just to make sure that everything is taken care of. Now, will is also helpful if you have minor children. So through a will, you're able to nominate a guardian or a set of guardians for your minor children in case something happens to both you and your spouse. Another important document in the estate plan is the power of attorney, or we abbreviate that to POA. So with this type of document, you're able to appoint someone to handle your finances and assets in case you needed help. So it includes things like, if you need help paying your bills or depositing checks, paying different types of taxes, or managing property on your behalf. So one advantage to a POA is that it is durable, meaning even if you create this document tomorrow when you're healthy and you're mentally sharp, it'll still work 15, 20 years from now if you become incapacitated, with Alzheimer's or dementia, or if you get into a car accident. At the same time, a POA can also be immediate, meaning it can be effective right away, right now, even before you become incapacitated. And this is often utilized by elderly parents. They find this useful because it allows their kids to step in and help them with things like filing their income taxes or paying off a credit card bill. The parents don't have to relinquish any control of their assets now. They can still pay all their bills if they want to, but these powers and these responsibilities are also extended to their children so that they can lend a helping hand if need be, so that either the parents or the children can assist in paying off the finances. So, I know a lot of you are young, you're probably healthy. So even if you're handling all of these things on your own right now, it's still a really valuable document to kind of just keep in your back pocket in case something happens later on. It's so important to create these documents before you get to a point when you actually need them. So another type of POA is called an advanced healthcare directive. Some people refer to this as a healthcare power of attorney. And this is a very important medical document that spells out what your medical wishes are, and it nominates a proxy to carry out these wishes for you if you're incapacitated. So it covers things like, would you want to be resuscitated? What type of surgeries or medications are you comfortable with or wouldn't you want? What are your thoughts regarding life support? Would you be comfortable using a feeding tube? Would you want to have artificial breathing machines or measures taken? So all of these types of wishes and preferences are covered within the Advanced Healthcare Directive. And, as we've seen throughout this pandemic, your medical state can change in an instant. So again, it's so important to spell out your wishes really for your loved ones. This helps eliminate the burdens and the feelings of guilt that they might experience if they have to make these tough decisions. So, instead of them feeling like they're taking you off of life support, they can be assured that they're just following your instructions. You say that I don't want to be a vegetable. If I have no brain activity, if there's really no chance of recovery, it tells them it's okay if you take me off of life support. So again, very important documents to have. And finally, the last document in the estate plan is a quitclaim deed or similar transfer document. So to avoid probate, the county, whatever county your property is in, has to be aware of the existence of a trust. That way, after you're gone, all your beneficiaries have to do is present death certificates to the county and a copy of the trust so that the property is transferred to them as the beneficiaries. But in order for the county to be aware of the fact that you have a trust, you have to file this type of quitclaim deed. And all this really means is instead of John and Jane Doe owning the property, the home is here on out owned by the John and Jane Doe Trust. So very simple change, but important recording that has to be filed with the county. So I actually took a look when you guys were filtering in, and I see a couple of friendly faces out in the audience there. So I know for a fact that at least some people in this virtual room have an estate plan in place. And a lot of people think, once they create these documents, it's a one and done type deal. But that's not necessarily the case. So if you do have an estate plan already, but you might have created it quite a while ago, here are some things to consider. So first, is your living trust properly funded? And funded is just the term we use to mean are the assets in the name of the trust. The analogy I always use is to think of your trust like a fireproof safe. So the reason why you have a safe in the first place, right, is to protect your important assets, much like the way the trust protects your assets from probate. Makes no sense to have your safe if you leave your birth certificate, your gold coins, and other valuables out on the kitchen table. Similarly, you're not taking advantage of the trust if your assets aren't funded into it. Now, when you first created your trust 20 years ago, yeah, everything might have been properly funded then, but things are constantly changing. So since you created your revocable living trust, have you sold your home and purchased a new one? Have you invested in a rental property or bought a vacation home in Hawaii or Mammoth? Do you have a timeshare now? If so, you need to make sure all of these are in the name of the trust. This is a big one as well, and it's one of the questions that we received here. What about a refi? So when you refinance the house, the bank always takes the property out of your revocable living trust. That's because loans have to be secured in your name as an individual, not in the name of an entity like a trust. A lot of the times, the bank will say, yeah, we'll put it back into the trust. And they forget to do so quite often. Horrifyingly enough, it's more often than you would think. I actually have 3 probates just this year alone for people who had their trusts in place. They thought everything was kosher, but the bank took their homes out of the trust during a refi and did not put it back in. And as a result, we do have to go to probate. It's about $30,000, $40,000. So if you do refi, just make sure that the bank puts the property back into the trust after it closes. And if you're unsure as to whether any of your pieces of property are actually in the trust or not, you can just ask me or any other estate planning attorney. We should all have the software to identify whether or not things are in the name of the trust. Okay, next, are all of your financial accounts either in the name of the trust or have a beneficiary designated? This is probably the most neglected task I see as an estate planning attorney. So everything that has a dollar amount attached to it, checking, savings, CDs, retirements, accounts, investments, again, those should all either be in the trust or have a beneficiary. Otherwise, they will be subjected to probate. There are a couple of different rules on what needs to be in the trust versus what needs a beneficiary, just for tax purposes. So if you have any questions about, just feel free to ask me later on. And again, if you're unsure if your accounts are in the name of the trust or not, one quick way to check is to look at your statements. So if you get a statement from B of A, you look at the upper left-hand corner, and next to your name and address, if the word trust or TR appears, that's a good indication that it is in the name of the trust. A little bit harder to check your beneficiaries. That's something you'll physically have to do. It does not appear on a statement. So another consideration to think about is whether there have been any major changes within your family. So since you created your trust, have there been additions of children or grandchildren? If so, you might want to include them now as beneficiaries. I know a lot of my clients who are grandparents set out a certain amount for their grandkids' college fund. So that's usually a specific request that's common in the estate planning realm. Now, oftentimes when people create their living trusts when they're young, their kids are minors, and then so they name their siblings or sometimes even their parents as their trustee or as their POA or medical proxy. But if those individuals are aging right along with you, you might want to consider naming your older children or even your grandchildren for those roles if they're of age now. And kind of along the same lines, if you named a friend or family member who has since passed away, since you originally created your estate plan, you may need to update it to remove them and replace them with someone else. Another consideration is whether or not there have been any changes to the law. So estate and tax laws always changing, as we witnessed with Prop 19. So us attorneys are constantly updating our documents to comply with the law. Now, for married couples, the biggest change that we saw in the estate planning world was the treatment of the A-B trust, sometimes called the survivor's trust and the decedent's trust. So historically, these were used just as a way to save on taxes. But again, today's estate tax exemption is so high. It's $11 million per person, $22 million for married couple. It's really unnecessary to have this type of A-B trust for the general population. Now, I had a conversation with my husband who's a CPA, and he said, you know what, you might want to take a look at the exemption because it's set to drastically decrease in the future. It's expected to do that. So even if the estate tax goes down to 5 million or even 3 million or even to 500,000, the updated trust provisions account for those facts as well. Basically, it saves you money if you're above the exemption, but it doesn't force you to do anything unnecessary if you're below it. So if you created your trust 15 plus years ago, you probably have this outdated AB trust provision in place, which can be expensive and really just a pain for your spouse and family members to deal with if you pass. Older trusts might also be missing a crucial provision called a no contest clause. This was instituted by courts and attorneys who were just sick and tired of hearing families fight over inheritance. So what this clause says is that, the people that you've designated as the beneficiaries of your estate and in those percentages is what you intended. So if you're not named, it wasn't a mistake, it was an intentional omission. If you get less money than your brother, that was also intentional. So, let's say you have 3 kids and you leave everything to them equally. But in the last years of your life, your daughter lived at home with you and kind of cared for you. A lot of the times, the daughter in that instance will say, well, then I think I'm entitled to the home since I cared for mom. Regardless of whether or not that was the case, and regardless of whether or not that was your intention, if it's not specifically designated in the trust, it's not real. So if the daughter tries to contest the trust and basically say she was entitled to the home, she likely won't get anything at all. So a no contest clause prevents family from fighting because, they're cautioned that if they complain, they risk losing it all. Basically, you get what you get, and you don't get upset. And another change came in the late 90s with the passing of the Health Insurance Portability and Accountability Act. We call that HIPAA. So HIPAA laws protect your privacy when it comes to medical matters. Basically, these go hand in hand with the Advanced Healthcare Directive, and just make sure that everyone that you've nominated as a potential medical proxy can have access to your medical records so that they can make an informed decision if need be. So if you did create your Advanced Healthcare Directive 20 plus years ago, you probably don't have this companion document to accompany it. And lastly, if you created your estate plan a long time ago, you have to remember to keep a list of your assets. So if you were to pass away tomorrow, would your kids or would your family members know what to do with your assets? Would they know where you bank or what life insurance policies you have? Would they know what company to contact regarding your 401k? So a lot of the times kids come in to see me after their parents pass and they have no idea where to start. They give me their parents' names and their social security numbers, and they ask me to, look up in a magical database what their parents had. But unfortunately, that does not exist. I wish it did, but unless, your kids know exactly what you own, exactly what accounts you have, I'm not able to locate that after the fact. So what I recommend doing is to keep a current and updated list of all of your assets. Again, checking, savings, investments, stocks, safe deposit boxes, and at what branch you have it at, etc. If you close out an account at Bank of America, cross it off the list. If you open up a CD at Chase, add it on. Keeping a general inventory of your assets makes things so much easier for your family members after you're gone. And I'd also recommend keeping something called a personal property memorandum. And this is just a specific list of items that you want to give to specific people. So believe it or not, kids are always fighting about mom and dad's stuff. So mom's engagement ring, dad's gold watch. Keeping track of kind of who gets what avoids potential disputes later on. And it's also really helpful if you want to give a, smaller sentimental gift to someone who might not necessarily be the beneficiary of your estate. So for example, your nephew might not be the one who inherits the home or a sum of money, but you might want to give him your baseball card collection. So this would be a good way to make sure that he gets that gift directly from you. And that is pretty much it. Those are all of the estate planning documents I recommend that everyone have in place. I really cannot stress this enough. Please think about getting these documents done sooner rather than later. Again, if the pandemic has taught us anything, it's that anything can happen to anyone at any time. I actually had a client earlier this year who was in the hospital for a non-COVID medical matter, and she wanted to get her affairs in order. I drafted all of these documents for her, went to the hospital to have her sign it, but because of COVID protocols, I wasn't allowed in. They wouldn't even take the documents into her to sign with a notary. So unfortunately, she did end up passing away, and now I'm working with her daughter to facilitate the probate. Even though she fully intended to have everything signed, even though I had all of the information, it was not signed and notarized, so it wasn't legal. Now the daughter, only child, she's inheriting one home here in Gardena, and the probate is about $35,000. So, we never know what the circumstances are going to be at the time when we pass. And even though I completely understand that it's morbid to think about death when you're perfectly healthy, that's actually the best time to do it though. I mean, it's always best to have your estate plan in place when you don't need it. That way, everything's already in order if and when you eventually do. So if you're interested in creating or in updating an estate plan, I'm currently meeting with clients via Zoom and in person. My main office is in Torrance, but I also have quite a few satellite locations that you can see here. Everyone always asks me, how come you have so many offices? The company that I rent my main Torrance office from owns buildings in all of these cities. And so I'm able to travel to those locations to use their conference rooms. So if there's a location that's more convenient for you elsewhere, please feel free to take a look at this list and see if another office works better for you. I also do home visits, hospital visits, nursing home visits, all at no additional charge. So right now, what we're going to do is just take a look at some of the questions that were submitted beforehand, before we go into the chat box and the live Q&A. So excuse me for a moment, I'm just going to take a look at the questions here. So let's see. The first question is, what documentation is needed when you want to start this process? And actually, this surprises a lot of clients, but you don't need to bring anything to the first appointment. I don't need copies of property tax statements. I don't need bank account information. I don't need any of that. And I won't need it throughout the process. And that's because when it comes to the properties, as long as you have the address, I'm able to check the prior deeds with the county. Like I said, estate planning attorneys have access to that software. And as long as your estate doesn't exceed that $22 million or $11 million for a single person, I won't need the bank account information either. And that's because the only part of the whole process that I can't do for you is I can't change the beneficiaries on your accounts, obviously, right? Only the account holder can do that. So with the bank account information, I will give you the documents that you would need to take to the bank to let them know that you have a trust. But I'll never need that at any point. And when you put together that inventory for your family members, I won't need a copy of that as well. That's specifically intended for them to know. So you don't have to share any information like that with me. Okay, let's see. Sorry, just looking at the questions. The next is the total cost of the process. So the full estate plan, again, includes the revocable living trust, the will, power of attorney, advanced healthcare directive, and then ancillary documents to transfer real estate, personal property, and financial accounts into the trust. It usually comes as a flat rate of $2,000 for a single person, $2,500 for a married couple. The only other fee that would apply is if you own non-primary residences. So if you own rental properties, timeshares, vacant lots, the county actually imposes a fee to transfer those properties into your trust since they're not your primary residence. So it's an additional $250 per non-primary residence. Now, if you're coming in to update the trust, usually it's about $250 per document with unlimited changes within each document. Okay, let's see. The next question asks, does the advance directive supersede what's on record with the primary care physician or your doctor, or is it the most recently dated one? So it's kind of an it depends type situation. So technically, the most recently signed advanced healthcare directive governs. That's the one that supersedes all else. So if you have one on file with your doctor from 20 years ago, but you signed one last year, the most recent one governs. That being said, unless you provide the most recent one to the doctor, they won't know that that's in existence. So if you don't provide the most recent one to your doctor and all they have on file is the one from 20 years ago, they will go with that one. So that's why it is important to provide these updated documents to your physician if need be. All right, next question. Should the person creating the living trust tell the designated trustee that they are in the trust, or to keep it private between the person creating the trust and his or her lawyer? What about beneficiaries? Great question. So I always recommend that you let your trustee or executor, your power of attorney, and your medical proxies know that they've been designated for these roles, because hopefully if you're the one designating them, you're fairly close and you trust them. There's no way for me as the attorney to know if you've passed away unless someone tells me. So if you let your trustee know that they've been nominated and that they need to contact me or any estate planning attorney if you pass, that's the only way that it's going to happen. So yes, I definitely recommend that you tell your executor, that you tell your power of attorney, that you tell your medical proxy that they've been nominated for these positions. Also the alternates, because if your primary person is deceased or unable to act for whatever reason, the alternate needs to know that they're next in line. Now, beneficiaries, they don't necessarily need to know that they've been nominated. And that's because, if you create this when you're 30, your beneficiaries at 30 might not be the same as your beneficiaries at 70 or 80. So that's something that can be kept private, in my opinion. You're more than welcome to share it with them if you'd like, but that's definitely something that has to be done. The next question is regarding Medi-Cal and Medicaid. So here in California, we have Medi-Cal, that's basically Medicaid in every other state. The Cal stands for California. And if that's something that you're interested in learning more about, it's a lot of information, so I'd be happy to discuss that with you kind of offline, so feel free to give me a call or set up an appointment for that. But I do Medi-Cal planning, which helps pay for nursing home care without having to expend all of your savings or funds like that. Okay, and that's it that I have for the questions beforehand. So I'm actually going to stop the screen sharing and open it up to the chat box. So Stephanie, do you want me to go through the chat box? What's the best way to do this?
I can relay the questions to you. So the first one, sorry, let me go up. First one is from Grace. What is the fee associated with creating a living trust? And was that already answered, right?
Yes, so it's going to be for a single person, $2,000, married couple, $2,500, an additional $250 per property for non-primary residences. And for updates, it's $250 per document.
Okay. The next one, are there any considerations for this 529 or 529 plans?
For 529 plans, and if you have 503B plans as well, those are beneficiary driven. So all you need to do is designate beneficiaries for those. You don't have to associate those with the trust. They will not go to probate.
Okay. And next question, about how long is the process of starting up a living trust?
Good question. So usually I meet with my clients for an initial consultation. We basically go through, what we did in the webinar today, what the documents are. I'd also collect the information I would need to draft the documents. That meeting takes approximately 45 minutes to an hour. Takes me about 2 to 3 weeks to draft the documents from there, at which point we would meet for a second appointment, review the documents together, and if it looks good, we sign it into effect right then and there. So the whole process takes about 3 weeks, assuming that you have all of the information readily available at the first appointment. If not, it might take a little bit longer.
Okay. Next question, if you designate 2 trustees and one of them becomes incapacitated, will the second trustee take over, or how does that work?
Typically, yes. If you have 2 co-trustees and one becomes incapacitated or refuses to act, the surviving trustee will act as the sole trustee. It all depends on how it's written, but typically, yes, that's how it would work.
And the last question on here, thank you for the info. Just got married last month and only one spouse is on the title of the mortgage. Do we need to put both spouses on the title first before establishing the estate plan?
No, not necessarily. So a lot of people have, sole and separate properties that they've acquired prior to the marriage, or property that they inherit from their parents that's in their name alone. If it goes into a joint trust, if only one spouse is on title, that's fine. All that means is, if it's wife's separate property and she passes away, husband gets the property after she passes. If she does not want it to go to husband and instead wants it to go to her children or to her siblings, what I would recommend is setting up a separate property trust to designate who the beneficiaries of that specific property would be.
Okay. And then next, if you don't have a trust or will your accounts with beneficiaries go to the beneficiaries automatically?
Yes, they will. So naming beneficiaries is a good way to avoid probate as well. Usually what I do though is I do have my clients name the trust as the beneficiary to avoid probate. So this is really the circumstance why I recommend putting the trust. So let's say you have two kids, right? Son and daughter, and each child has their own children, so your grandchildren. If you name son and daughter as the beneficiaries on your trust account and son dies, daughter gets 100%. Whereas if you name the trust as the beneficiary, if son dies, daughter gets 50% and son's children get the other 50%. So at least your son's bloodline is honored in that regard. That's the only difference. In all likelihood, when people name their kids are going to survive them. It's just in that contingency situation, the trust offers more protections. Also, let's say you name your son and your daughter as your beneficiaries, and you guys are flying on a plane to Hawaii and the plane crashes. There are no beneficiaries there and it goes to probate. Whereas if you name the trust always has those alternates in place. It says it'll go to my grandkids, or if my grandkids aren't around, it goes to my next of kin. So it has a little bit more protection than naming beneficiaries, but it is up to the client what they'd like to do there.
Okay. And then next, is the personal property memorandum similar to a will or different?
They're different. So the will's intention is to make sure that all of the remaining assets get transferred to the trust. The personal property memorandum specifically designates, I want my baseball card collection to go to my nephew. I want my daughter-in-law to get my fishing rods. So it's more of a specific designation with the personal property memorandum.
Okay. And it looks like that's all the questions in the chat, but so we'll open it up to verbal questions. So if anyone would like...
Sorry, Stephanie, sorry to interrupt you. I have a couple of direct messages that I'm going to read.
Oh, okay.
Okay. So the first one says, how secure is the power of attorney and advanced healthcare directive with regards to DNR and other family members are adamant to counteract at a hospital emergency situation? Does this ensure that the hospital will have to follow the DNR as stated by the POHAHD? I'm assuming that's the advanced healthcare directive. So it's a little bit difficult to answer, but basically the advanced healthcare directive is drafted in a way that is intentionally vague. And the reason why we say that is because what it says is, if the burdens of treatment outweigh the benefits, I do not want to be resuscitated. Take me off of life support in that regard. Ultimately, that is left up to your medical proxy to make the final decision. That's kind of just a statement of your wishes, just because every situation is different. You don't want to say, take me off of life support in every situation, or keep me on life support in every situation. So it gives a lot of discretionary power to the medical proxy. Now, once you're at the hospital, if you have an illness where you only have a couple of months to live, usually you fill out a different type of form, a POLST, which goes a little bit more into detail with, an impending death. That is a little bit more secure than the advanced healthcare directive, but usually you only sign that if you have a terminal illness. So I know that, in some situations, families are always fighting about keeping mom on life support, keep taking her off life support, but ultimately whoever you appoint as the medical proxy, they're going to have the final say. That's why I caution people to be aware of having co-medical proxies specifically, because if people, if your kids get along fine up until that point and they disagree, then usually an intermediary has to step in. So I usually recommend having a tiebreaker at that point, or adding on a third person so it's a majority vote. Okay, my next direct message says, is it okay to leave the bank checking account alone, not put in the trust as long as you specify the beneficiaries for the account? So yes, that's similar. You can. It's a little bit more secure to name the trust for contingency purposes, but having beneficiaries does avoid probate. Okay, let's see. Sorry, we have a couple more. We'll be receiving the slides afterwards. Yes, I can. I'll send out a PDF of the slides to Stephanie, and I think she's going to disperse those to everyone after the fact, along with the recording of today's video. And do you provide 2 original copies of the trust, one for the lawyer and one for the client? So when I create the estate planning documents, the client receives all original hard copy wet signatures. I retain an electronic copy. So I don't have any physical paper copies here at the office, just because it's a little bit more eco-friendly, but also I just don't have the space for that here. I also think having it electronically is more secure. So I upload it onto a secure server that I pay for. That way, if you ever need an electronic copy in the future, I can email that to you. Also, you'll see a clause in all of the documents that say that electronic copies have the same effect as the original. So it doesn't matter if you lose your originals or they get lost or, destroyed in a fire, electronic copies will always suffice. And I think that's it for the chat box, unless I missed any. So I guess we'll open it up to live questions, Stephanie.
Yes, so anybody that would like to ask a question here, go ahead and unmute.
Hey, Stacy. Thanks for that session. It was very insightful. Quick question about the flexibility as far as, let's say, I bought a house here in Gardena with my wife 2 years ago.
Mhm.
And if we engage in a trust together, and then let's say we get divorced or something, like how flexible are, changes to that trust if something like that should happen, out of curiosity?
Right. So during the divorce proceeding, that's actually one of the questions that the attorney asks you, the divorce attorney, the family law attorney. They say, do you have a living trust with joint assets? During the separation decree, what they'll do is, if it gets split equally 50-50, they'll take the property out of the trust, distribute it 50-50 to husband and wife, and then dissolve the trust itself. And then at that point, husband and wife or ex-husband, ex-wife would then create their own separate property trusts to put their 50% of the property into.
So what's like timing, as far as like flexibility in timing as far as those proceedings go, out of curiosity?
You mean if a divorce were to occur?
Right.
That I don't know on that side, just because every attorney is a little bit different in terms of, if court involvement needs to occur. For those purposes, it's up to the judge and what their calendar is available for. I just did something similar to that with one of my clients, and the whole dissolution of the marriage as well as the trust took about 6 months.
Gotcha. Okay. Cool. Thanks.
No problem. Let's see. I'm going to go back to the chat box. I got one more question here. So it says, spouse died after the current trust was created. Will the trust have to be recreated, and will you charge $2,000 for it? It depends on what needs to be updated. Just because a spouse passes does not necessarily mean the whole trust has to be redone. It might just need to be amended, which is a $250 charge. So it depends on how much you'd like to change. If it's just a matter of the spouse passing away, definitely not $2,000. If there are multiple changes that need to be made, it just depends on how much you'd like to change.
Any other questions? Okay. I guess if there are any other questions that you do have for Stacy, feel free to email me and I will relay those to her and she can share those answers with you. Otherwise, I guess last call though. Any question? Okay. Okay. Okay, I guess no more questions. So thank you all for joining us.
Sorry, Stephanie, one just popped up.
Okay.
On Medi-Cal, after trust was created, will it need to be recreated? So if you're already on Medi-Cal, then likely in order to get qualified, you've already gone through the steps to protect the assets. So no, so you're able to be on Medi-Cal and keep your primary residence, as long as that's protected by the existing revocable living trust, no changes need to be made there. And then next it says, do you need a lawyer to close a trust? Oh, this is a great question. So after the creator of the trust passes away, the process afterwards is called trust administration. When property is involved, meaning if there's a home, if there's rental properties at all, I definitely recommend that you work with an attorney to transfer those to the beneficiaries. Because if the proper paperwork isn't filed, all kinds of messes happen. I mean, property taxes increase, supplemental taxes are due. If you don't provide certain copies of trusts or certain propositions, I mean, it's just a big old cluster. So I've had many families in the past try to do the property transfer on their own, and they just had a slew of problems. So if you think about it yourself, you know, would you know how to create an affidavit of death, or would you know how to properly file the preliminary change of ownership report? Those need to be done with an attorney. If you're just talking about bank accounts and there's no real estate involved, I do think that can be handled by the individual themselves. I would just consult with an attorney first, maybe just get a free consultation to make sure you're covering all the bases, because there are some things like a 16061.7 notice that all executors are required to send out to family members. So you just want to make sure you're doing your due diligence and that you're performing all of the duties that are required of you as the executor or trustee. Next question, how do we make an appointment with you? Can it be in person? Yes, absolutely. So if you'd like to make an appointment, you can either give me a call or shoot me an email and we can set something up. I am doing in-person appointments at all of my offices as well as virtual. I just ask, I know there's the mask mandate has been lifted in some areas, but I do request that you do wear a mask in person, even if you have been vaccinated. Otherwise, we can do it virtually or by phone. I believe in the handout that Stephanie's going to be emailing out to you later on, it'll have all of my contact information on it. Otherwise, my name is Stacy Toji. You can Google me.
Okay, and I actually just got a direct message question here. If a client doesn't own any properties but has a retirement account and other savings, but that's it, would a trust/will be helpful for the beneficiaries or a waste?
Personally, I don't think it's necessary to have a trust done if you don't own any real estate. A will is helpful in case anything after the fact comes up that doesn't have a beneficiary, like I said. If people are trying to save money and they are only trying to get the documents that they really need, then technically you probably don't need a will, but I would definitely recommend a power of attorney and advanced healthcare directive, regardless of whether they own real estate or not. Those are the two documents that I recommend everyone have, even if you're young. So I just did POAs and advanced healthcare directives for all of my cousins who are off to college in the fall. They're 18 now, they're legal adults, so their parents really aren't going to be in charge anymore. So if anything happens to them, we want to make sure that their parents still have the authority to act. So if you guys have college age kids, that's definitely something to think about as well.
And then we have another question. Can you check our current trust and update it for us? There has been many changes since it was created years ago.
Yeah, absolutely. So I conduct trust reviews all the time. Those are always complimentary. All of my consultations are. So we would just review the trust. I'd let you know what it says and remind you of those. A lot of the times, if it was done a long time ago, my clients say, oh, I don't even remember appointing that person. So I'll let you know what the provisions say. And then I would also give you my recommendations, if any, for modification.
So it looks like that's it in the chat, but anybody else have a verbal question, or if you have any other last minute questions for the chat, maybe I'll just give you guys 30 seconds.
Thank you, guys. Thank you in the chat. Oh, okay.
Okay.
All
Well,
right.
I guess that's it then. So thank you again, everybody, for being here. And thank you so much to Stacy for this really informative presentation, really important information to have. So yes, I will definitely email everyone the slides, the handout with the outline of today's presentation, also the video recording. And again, if you have any questions for Stacy, just feel free to email me and I will send them to her. Otherwise, thank you, everybody, and enjoy the rest of your weekend.
Thank you so much. Have a good one.
Thank you. Bye.